Call all rise.
Judgment in the appeal, Pora and the Queen.
In March 1992, a woman called Susan Burdett was raped and brutally murdered in her home in Papatoetoe, New Zealand. The following year, on the 18th of March 1993, Tēnā Pora, who was then 17 years old, was being interviewed by police officers about his stolen vehicle. In the course of that interview, he asked the police whether they had arrested anyone for the murder of Ms Burdett. When he was told that they had not, he said that he knew who had committed the crime. There then followed a series of interviews over the course of 4 days, during which the appellant, Mr Pora, gave various accounts, first of his knowledge of, and later of his involvement in the burglary, rape and murder of Ms Burdett. He was duly arrested and charged with those crimes. The jury on his first trial was told of the various confessions that he had made. Mr Pora gave evidence at that trial, and he denied having anything to do with the rape and murder of Ms Burdett. But he was quite unable to explain why he had made the confessions. And it cannot be a matter for surprise, therefore, that he was convicted of the offences. He appealed against his convictions to the New Zealand Court of Appeal, and that court allowed his appeal after it heard that another man had been convicted in the meantime of raping Ms Burdett. Since no evidence about that other man's involvement had been given on the first trial, and the first jury had therefore no opportunity to consider whether this might have a bearing on whether Mr Pora was indeed guilty, the Court of Appeal considered that he should be tried again. He was tried again, and again he was convicted. At the second trial, Mr Pora did not give evidence, and no explanation was offered to the jury for his having confessed to the crimes. He appealed again, but this time the Court of Appeal dismissed his appeal. He was sentenced to life imprisonment, and until he was granted parole last year, he served a lengthy term of imprisonment. Now, in February of last year, Mr Pora applied to the Judicial Committee of the Privy Council for permission to appeal against his convictions. And he was given permission to appeal for two main reasons. The first was that reports from a series of experts had been obtained by his lawyers, and it was said that those reports cast doubt on the reliability of the confessions which Mr Pora had made, and which, for the first time, gave explanations as to why he might have made false confessions. The second ground was that certain evidence concerning the man who had been convicted of the rape of Ms Burdett had not been given at Mr Pora's second trial. And it was claimed that if that evidence had been given, it would have shown that that other man is likely to have acted alone in his attack on Ms Burdett. Mr Pora's appeal was heard by this board towards the end of last year. The board was invited to receive evidence from three experts. Professor Good Johnson, a clinical and forensic psychologist, Dr. Valerie McGinn, a clinical neuropsychologist, and Dr. Andrew Immelman, a consultant psychiatrist. For reasons that the board explains in its opinion, it was decided that the reports of Dr. McGinn and Dr. Immelman should be received, but those of Professor Gudjonsson should not be admitted in evidence. What Dr. McGinn's and Dr. Immelman's reports showed was that Mr. Pora suffered from a form of fetal alcohol syndrome disorder, FASD, and it was their opinion that this condition could explain why Mr. Pora had made what are now claimed to be false confessions, and why those confessions could not be regarded as reliable. Having admitted those reports, the board concluded that the opinions of these experts called seriously into question whether the confessions could indeed be regarded as reliable. And since they were the central and critical evidence at both his trials, it was concluded that there was a risk of a miscarriage of justice if Mr. Pora's convictions were to be allowed to stand. The board decided, therefore, that those convictions had to be quashed and that Mr. Pora's appeal had to be allowed. The board also concluded, however, that the second ground of appeal should be rejected. In the board's estimation, it was simply not possible to say that the evidence which the appellant claims should have been given to the second jury would have made the difference that it has claimed it would have. Finally, the board has decided that the parties should have the opportunity to make written submissions within 4 weeks as to whether the appellant should be ordered to stand trial again. Mr. Jant.